daily list item number 1.
Please, Your Lordship. Lordship, bill petition regarding the NDPS Act, Lordship. Lordship, here the accused person. Lordship, the brief fact of the case is that here the accused person, he was traveling along with his friend.
Have you issued notice?
Sir Guru. Sir Guru, I don't know where is he.
He's not here, so we'll wait for a while.
Item number 3.
1, 2, same.
Same connected matter, Your Lordship.
Yes,
It is, Your Lordship. Well, the petitioners are Mintris and Basans of the Milliam CM-ship, and together with several others, in total there were 22 complainants who had filed a complaint against the serving CM of Milliam in 2023. Thereafter, a reply was filed by the concerned CM, and rejoinders were exchanged between the parties. Well, the nature of the complaint was such that he had alienated certain properties belonging to the Milliam CM-ship to third parties in complete violation of the customary practices. There were several other discrepancies. He had not been filing annual audits. Dorbar Pilluns were not being held, and he was also not. He had also suspended the monthly salaries of the Mintris. So this was the nature and the basis of the complaint. He had filed his reply. Eventually, the impugned order which was passed dismissing the complaints is at page 339. Your Lordships have it. So please see, it's a 2-page complaint, 2-page order. In the first page, I'll read it. What he has done, he has summarized and captured the contentions of both the parties.
No, the complaint was filed before the
Executive Committee KHDC, my lord.
So this is the order of the executive.
Yes, my lord. This is the impugned order which I am challenging. I'll just read this, my lord. The matter was taken up by the Executive Committee KHDC, having received the complaint dated 26/10/23 and 9/5/24 from Mintri F. Sandor and others, where the complainant are aggrieved by the style and functioning of the CM, Milliam CM-ship. Based on the complaint petitions, the following queries were raised by the complainant, which are as follows. 1. That the CM had violated Section 7C and E of the KHDC Appointment and Succession of So-and-so Act of 2007. That the CM had violated Section 8A of the Administration of Milliam CM-ship Rules 2015. Matter concerning Yo Milliam Rim and other CM-ship land. Well, number 3 is the matter with regards to the ownership of the land. It is our contention that all these lands are vested, and the ownership of the entire lands are vested with the Milliam CM-ship. He had alienated it in favor of third parties, which is not permissible. Number 4, they were not given their customary allowances, financial irregularities and no proper audit, violation of customary practices of the HEMA, no Dorbar Pillun was held. So in total, he had raised about 7 contentions. Upon perusal of the show cause reply of the CM dated 7/11/2023 and 26/7/2024, the following is observed. The CM of HEMA Milliam in his reply stated that the complainants are baseless and unfounded. The registration of Yo Milliam Rim was previously made by the Lingdor during the year 2007. Number 3, he informed that Yo Milliam Rim falls under Ride Milliam. Number 4, the Mintri of HEMA Milliam stated that the complainants does not infructuous. 5, land compensation was done prior to Act rules of HEMA. Number 6, the Dorbar Pillun was convened during the year 2022 when he was the acting CM. Now, please note, my lords, he has summarized my contentions and therefore he has noted about 7 issues, 7 of my grievances. And thereafter, he goes on to decide these issues. To further ascertain the matter, hearing of both the parties was fixed on 2/7/24 and 27/8/24. Upon hearing the contention and oral submission, additional written argument was submitted by the complainants. The same will be served to the CM and his Dorbar for show cause reply within 2 weeks. Further, the CM and his Dorbar are to submit and clarify on the customary allowances of the Mintris. Upon due consideration of the facts, the Executive Committee has found that the Hima Milliam had issued Dulir-wide registration number so-and-so dated 2007 in favor of the Ride Milliam concerning the plot of land situated at Yo Milliam Rim, Ride Milliam, Milliam CMship. Furthermore, it has come to light through the order dated 3/4/2008 that the office of the KHADC has duly placed on record the aforementioned plot of land. In light of these findings, the Executive Committee is of the view that the compensation that is deemed to be compensated from the concerned authorities pertaining to the aforesaid plot of land should be granted to the right and not to the Hima. Therefore, the complaint against the CM of Milliam with regards to the compensation is not proper, as the compensation is to be paid to the right concerned. Now, I'll just point out what had happened here. We had contended that the Milliam market, as your lordships are aware, that belonged to the Milliam CMship. And what the respondent had done, that is the CM of Milliam, he had alienated this property in favor of Ride Milliam. This is a completely third party. Now, his contention is that there are two sorts of ride lands. One is Ride Re Glum and one is Ride Re Them. And he says that the Ride Re Them properties, which are lowland ride properties, they do not belong to the CMship. This is not as per the rules. And just around the same time, when these properties were alienated, the state sought to acquire the properties. And a compensation amounting to about 5.5 crores was then released to the Ride Milliam. So this is the nature of this particular dispute.
Who has disbursed the compensation?
The state, my lords.
State.
The state. So we are saying that the state could not have dispersed the property to, the compensation to them because the ownership lies with the Milliamship.
Acquired by the state.
Yes, my lords. For the purpose of expansion of the highway. Some area of the property was acquired. Now read the next paragraph, my lord. Additionally, the Executive Committee do hereby observe that the honorarium should be provided to all Mintris irrespective of their affiliation with the opposition. Hence, the arrears of the honorarium which have not been provided to the concerned Mintris shall be disbursed in a way of an installment. Our grievance here was that our monthly allowances were not being disbursed. Now, in his reply, he says very brazenly that these people have been filing cases against me and they are in the opposition. So, therefore, I've suspended their monthly salaries. This was his reply. So with regard to that, no punitive action is taken. In fact, it is just a slap on the wrist and they say, please disburse the amount by way of an installment. Then can you see the next paragraph? Moreover, with regard to the complaint against the CM of Milliam violating the section 7C and 7E of the KHADC so-and-so Act of 2007, as well as section 8A of the Administration of Milliamship Rules 2015, the CM has not undermined the authority of the Executive Committee nor violated any customary right and prevailing practices prevailing within the Milliam CMship. Therefore, based on the above findings, the Executive Committee, after due deliberation and diligence on the matter, as well as considering the smooth administration of the Hima, has decided that the complaint petition has no merit and is hereby dismissed. Moreover, for an amicable administration, the CM Milliam CMship should strictly adhere to the acts and rules of the Hima, and that there should be conformity with the prevailing practices within the CMship. My lords, in my humble submission, this is a completely non-reasoned order, a two-page order. The first page just summarizes the contentions of the parties, and the entire reasoning is contained in one single page. The complaints, there were about two sets of complaints, detailed complaints, and he also gave a detailed response. Now, there is nothing to understand what his reasoning was. It's therefore a completely non-reasoned order and a perfunctory order, my lords. And we are selling this particular order. I have also made the CM of Milliam a party. Notices may be issued for the timing, lords.
No, I'm appearing for respondent number 1 to 6.
KHADC.
KHADC.
That 7 is the office of the CM of Milliam at page 6, my lord.
And 8, 9, 10.
So 7 and 8 months, Aina Manik CM, he's the serving CM of Milliam at present. I've made him a party in his personal capacity as well. And 9 and 10 are the chairman and secretary of Ride Milliam. So we made allegations against them as well. So these are private parties. So I'll issue notice upon 7 to 10, my lord.
These 9 and 10, were they part of the proceedings
Yes.
before the district council?
No, they were not part of the proceedings, but allegations were made against them, my lord.
Okay. So they have not joined issues.
They did not file any reply before the executive committee. But nonetheless, Manoj, there are serious allegations against them. If I don't make them a party, KHDC will take a plea that I have not made them a party.
No, any ex parte observation made against them?
No, nothing at all. There was no discussion with regard to their participation.
Excuse me. Heard Mr. Hassan, learned counsel for the petitioners, who has submitted that this petition is filed by the petitioners being aggrieved by the order dated
At page 339, 22 October 24.
22 October 2024. Which is the response of the chief executive, response of the KHADC, executive committee of the KHADC, to the complaint made by the petitioners dated 26/10/2023 and another one dated 9/5/2024, primarily against the respondent number 7. However, at this, the respondents number 126 KHDC has accepted notice of the same, of this petition, and has entered appearance to Mr. R. Asad, then counsel. As prayed for, let notice be issued upon respondent number 7, 8, 9 and 10 respectively. The same returnable within 2 weeks. In the meantime, the petition is admitted.
Obliged, my lord.
Obliged.
Item number 4.
None has appeared for the parties. This is matter of 1 week.
Item number 5.
This is that bonded warehouse. 4 matters are listed for my lord. My lord, the first one is from by wife, my lord, Kausalya Rukmani, and this is in regard to Bagmara case, my lord. My lord, the lordship is pleased to grant interim bail, my lord,
Yes.
by order dated 13/2/2025, and after that, my lord, when they came to appear, because they are required to appear in 2 police stations, my lord, Khanapada and Bagmara. So when the husband and son appeared in Khanapada, my lord, the wife was waiting. They were arrested in connection with the POXO case, my lord, from there. Then they were taken to Garhwals, my lord. Then another 420 case clamped on them, my lord. And then they were in custody for so many days. Lordship aware, I placed on other occasion. And because of that, it appears that in Bagmara case, their presence has not been recorded, my lord. Though they were there and they were picked up from one police station to other police station, my lord. My lord, in first item, what I would pray, my lord, your lordship will kindly make the bail absolute, my lord. If necessary, but whatever means, if it is required to appear online, virtually, my lord, because going to Bagmara, again they'll clamp. What happened, my lord? Mr. Nongburi has informed me, they've clamped another case in Khanapada against them under Prevention of Corruption Act now. If necessary, I'll bring that on record, my lord. He sent me an FIR just last night that now under prevention of crime. This is a little too much, my lord. When the matter is before your lordship, my lord, they should be a little circumspect in doing this, my lord.
Yes. Ms.
Lordship,
Tani.
with regard to the instant application, item number 5, Lordship, we had submitted the extract of the CD and also the status report before this Honourable Court, my lord, on the last date.
This is with regard to this Bakmara case.
Bakmara case, Lordship.
What is yours submission?
Lordship, as is evident from the status report, Lordship, the accused persons have been evading arrest right from the time when the case pertaining to Tura, Lordship, was an FIR was filed against them, Lordship. And with regard to the same, they had come before this Honourable Court filing for anticipatory bail, and the same was granted to them with conditions, Lordship. However, Lordship, since the time that the bail has been granted, Lordship, they have been evading to cooperate with the police, Lordship. Lordship, in furtherance of the same, Lordship, lookout notice has been issued. Non-bailable warrant for arrest has also been issued, Lordship. They did not cooperate. Moreover, on 15th of October 2024, Lordship, the IO, the inspector herein, had personally went to Jaipur, Rajasthan, Lordship, to attempt to arrest the accused person, Lordship. But even there, it was a futile effort, Lordship. So thereafter, what had transpired thereafter, Lordship, is they came voluntarily to Khanapara, Lordship, wanting to meet the IO. Lordship, that was just right before the MDC elections. So they were informed that the IO was not available as he was on election duty. They stayed there voluntarily for the time being, Lordship. In the meanwhile, Lordship, the other jurisdictions, that is Tura, they came to be aware that they were there. Now, Lordship, prior to them being present in Khanapara PS, Lordship, there was already another FIR filed by one of the witnesses to Tura case, Lordship, whereby the accused person had called them up and threatened them over the phone, Lordship, threatening the entire family, including to many other things against the minor daughter, Lordship. So over there, POCSO provisions were drawn. In that matter, Lordship, accordingly, as soon as Tura PS came to know that they were present in Khanapara PS, they asked them to make them wait over there. They will send a police team to pick them up because now POCSO has been attracted, Lordship. So accordingly, they were asked to wait at Khanapara PS and the team arrived. However, since the team arrived very late, they left the next morning, Lordship, and they arrived at Tura PS. However, after consideration of the same, because the threat was made only via phone call, Lordship, so POCSO, the charges under POCSO, I mean the provision of POCSO was they had decided not to arrest the person, Lordship. So, my Lord, from Khanapara PS to Tura PS, they were detained, and it is wrong to say that it was more than 24 hours because they were not detained in Tura PS, Lordship. As per the status report given by the SP, Lordship, they were lodged in a hotel, Lordship, because when they reached Tura PS, a notice was served upon them, Lordship, for taking of statement. Tura PS made no attempt to arrest them, Lordship, because of the anticipatory bail granted by this Honourable Court. It's only because of the new FIR that was filed that their presence was mandatory in Tura. However, they were not arrested and they lodged themselves in a hotel for the night, Lordship, so that their statement can be taken on the next day. Lordship, on the next day, their statement was taken. In the meanwhile, a call was received from Ampati PS, Lordship, that they were wanted in They were wanted in Ampati case, Lordship. And accordingly, the police personnel from Ampati came and immediately they had produced them before the magistrate, Lordship. So, the allegation that they were not produced before the magistrate for a certain number of hours exceeding 24, Lordship, is absolutely wrong. Because there was no detention, no detainment in Tura PS, Lordship. They stayed in hotel, Lordship. The records are available, Lordship. And they came to Tura PS on the next day to come and give their statement. But because of the pending FIR in Ampati, Lordship, they had to wait for Ampati team, and accordingly they came. They picked them up, produced them before the medical officers and also the magistrate, who had granted judicial custody. Thereafter, on the next day, Lordship, they moved for bail and they've been granted bail, Lordship. Now, my Lord, I beg to submit, Lordship, that there are many FIRs lodged herein with regard to the same accused person. And now jurisdiction has come to 4, Lordship. Initially, it was Tura. They had gotten anticipatory bail over their, Lordship. Then Khanapara, Ampati and Bakmara. Lordship, with a very, very fair submission, Lordship, they have not been cooperating with the police at all. Immediately on attaining bail from this Honorable Court, Lordship, since the month of Lordship, since 27 of August 2024, Lordship, the court had granted, this Honorable Court has granted them bail on certain conditions, that they shall appear before the IO and not abscond. They have totally violated this condition, Lordship. They never appeared before the IO. They never cooperated, to the extent that this is an August order, Lordship. The police personnel from Meghalaya had to travel all the way to Jaipur, and there also the effort proved to be futile, Lordship. It's only in February, Lordship. They're taking undue advantage of the protection granted to them by this Honorable Court, Lordship. More so, during with this anticipatory bail being made absolute, Lordship, they've taken advantage to the extent that they call up witnesses and threaten them, my Lord. This is all during the course of the exercise of the anticipatory bail granted by this Honorable Court, my Lord. So, my Lord, now coming with the plea that the police personnel had violated their fundamental rights, detained them for more than 70 hours, filing a habeas corpus case before this Honorable Court, my Lord. This is just to seek, I don't know, compassion from this Honorable Court, my Lord, when it's not deserved. Because looking at the FIR, Lordship, it is mostly commercial evasion, Lordship, whereby tax evasion has been committed by the accused person. They have taken money from the complainant, the first complainant, Lordship, and left station. Absolutely no cooperation. It's been more than 6 months, my Lord. The investigation has come to a stop. Why? Because they have been evading arrest till date, Lordship. So, my Lord, these cases are all connected, Lordship. And with regard to Ampati, they got bail the very next day, Lordship, after production before the nearest magistrate. So, my Lord, this is a very clear-cut case, Lordship, that these people are habitual offenders, Lordship. The court has granted them anticipatory bail at the initial stage, Lordship. To grant them any anticipatory bail from today, Lordship, would render in failure of the investigation, my Lord. Because this Honorable Court had given them a chance, Lordship, to appear before the IO and cooperate. They failed, my Lord. They failed to do so, and instead now have leveled allegations. And with regard to the allegation that new charges have been added, my Lord, I'll submit a status report, Lordship, from Reboy before this Honorable Court. My Lord, this is the reason why new heads have been added, my Lord. My Lord, at the heading, accused person offering bribe to police officer, my Lord, if I may read.
Yes.
Between 2030 hours to 2100 hours, both the accused persons named above offered a bribe of rupees 10 lakhs to the police officers on duty for helping them to let go without arresting and to help them to get anticipatory bail from the court. The same was recorded in the GDE number 12 dated 16th of February 2025 at 2100 hours. In this regard, a cognizable case White Kannapara PS case number 0502-2025 under sections 8, 12, 15 Prevention of Corruption Act 1988 has been registered and being investigated, my lord. They are taking undue advantage of the order dated 29/8/2024 granted by this honorable court lordship. They are committing further crimes, threatening witnesses, offering bribes to police officers, lordship. I am raising very strong objections for the anticipatory bail application filed by them, my lord, of all the accused persons. And this is on record, lordship. This is a report filed by the senior superintendent of police. These are very serious allegations, lordship. But when this failed, then came the violation of human rights case, which is absolutely false. And further, making a counterclaim that the police had demanded 10 crores from them, which is fabricated, lordship. So at this stage, lordship, I object to any anticipatory bail to be granted.
See, Dr. Zika,
Well,
I think, of course, we are well aware of the principle of bail. If the court is to consider any application for bail, first we have to look into the nature and gravity of the offence alleged.
well,
Here the offence may be, as far as this matter is concerned, maybe of a commercial dispute nature. Then more importantly, it is the court has to also to look into the antecedent of the parties or the petitioner for that matter,
well,
and the conduct.
well,
Now all these things, if we summarize every allegation that has been made against you, would point a finger that you have been amiss as far as your conduct is concerned.
I'll answer that one.
Of course, you see, there has been allegation and counter allegation. Now the latest complaint against you is offering of bribe, which you may deny, may not. You in your turn has also made allegation against the police demanding. Those are all, you see, subject to evidence. At this stage, this court cannot do anything.
But
Cannot observe.
My lord. Well, I'll just point out a few things, my lord.
So now what is required? If we take one case at a time.
My lord.
As far as this case is concerned, Bagmara case is concerned, you are directed to appear for the IO, which according to them you have not.
I'll try to explain, my lord.
But now in your turn you say that you are prevented by being detained, having gone to Khanapara and so on and so forth. What do we do?
My lord, I'll just point out a few things, my lord. My lord, in Bagmara case, the item number, the first and second item, the first petition is by wife, my lord. My lord, kindly see, there are no further allegations against the wife. Wife is not involved in that POCSO case also. Wife is not involved in the prevention of corruption case also, my lord. And being a housewife, my lord, your lordship will treat this application on a different footing, my lord. That is my humble
But
submission.
what is the apprehension of the wife?
My lord, she is named, my lord.
Or name?
Just,
Name in the FIR?
what was that?
Lordship, in this matter, my
I'll
lord,
can I just complete?
is in the status report, lordship. of Baghmara PS, which was submitted to this Honorable Court on Friday, Lordship.
Hey,
My lord, kindly, Lordship, kindly seize the FIR, my lord. At page,
that is good.
Lordship, this will be by Baghmara PS. Status report, reference Baghmara PS case number.
Yes.
Lordship. Towards the end, my lord. Second page. Just with regard to the instant application, my lord.
page 17.
Yes, 17.
Page 17 is the content of the FIR, my lord. I'll just read, my lord. To the officer in charge, Baghmara Police Station, South Garoil, so-and-so. Subject FIR. Sir, with due respect, I beg to state that I, Chinkan W. Momin, daughter of late so-and-so, would like to file a case of Section 420 IPC against Sri Gopal God, son of Motilal God, Siddharth, are resident of Chhatribadi, Guwahati, permanent resident so-and-so, Jaipur, Rajasthan, that Sri Gopal K. God had been running my bonded warehouse license by power of attorney since the year 2007, that he had been running many other bonded warehouse in Meghalaya, namely Gloria, West Garo Hills, Sweetie, South West Garo Hills, including Planet bonded South Garo Hills, for all these years up to the year 2021, but now he is ghosted from paying all the due taxes which he is liable to pay to the government of Meghalaya, namely the taxation and the excise department. That all means to contact him personally has gone in vain because he has switched off all his number, that is so-and-so, that he is solely liable to pay if the taxes as per the agreement deed. That same is the fate of Sweetie bonded warehouse, South Garo so-and-so. Also, this is not the first FIR of the said case. On December 14th, 2021, FIR was filed for the same, but the OC of Baghmara Police Station refused to register same. Also, mere so-called notice from the concerned department and damage suit against him will not suffice, since his whereabouts are unknown because he is intentionally avoiding to pay the taxes and police intervention is needed for the said case. Yours faithfully, Chinkan Su. Well, the allegations in the FIR, kindly see. He says that simply filing a money suit will not do because his address is not known. My lord, our jurisprudence does not permit this kind of action, my lord. What is a civil dispute will remain a civil dispute, my lord. To make out a case of 420, there are several other ingredients. None of the ingredients are present even in the FIR, my lord. So, in my humble submission, my lord, this is a fit case, my lord. Not even a criminal case is made out, my lord. The FIR itself says that the civil suit will not do because his address is not known. That's one aspect, my lord. Second aspect, my lord. In respect of Tura, the petitioner have been granted absolute bail by this honorable court, my lord, since July. If they feel that they have not complied with any terms and conditions, my lord, is that not inbuilt in the bail order, my lord, that they should file an application for vacating or modifying the interim order? In my humble submission, they have not done it for last 6 months, my lord. Now they cannot raise that issue in the present proceedings, my lord. That is my second submission, my lord. Even today they can file an application for vacating that interim bail on the condition, but then they'll have to prove, my lord, that when and how when they called, when they did not appear, because they don't have any material. So leveling just baseless allegations, my lord. If they have a basis for that, they must file an application for vacating the bail order, my lord, or for recalling that bail order. That is my second submission, my lord. Third submission, my lord. It is an admitted position, my lord, pursuant to the interim order granted by lordship. The father and son went to Kharampara police station, my lord.
No, let us do one thing.
My lord.
Those would be, you see, your submission would touch on the other matters.
Subsequent conduct.
So let us
as far as first, my lord, that will be my submission, my lord. That she is a housewife has nothing to do with the husband's transaction, my lord, and what business husband does. And she's an elderly lady, my lord. The husband is about 63 years also. Just point out the age, my lord.
Here only see notice under section 35(3) was
issued, my lord.
so you have to respond to that notice.
My lord,
The report here says that you are sick and could not comply. See, what happened is, if a notice has been issued to you, number one, we are sure that no arrest will be made. Number two,
my lord, kindly note, my lord, only one aspect, my lord. This notice is of 23 March 2022, my lord. Page 28, your lordship is. And my lord, looking at the way the police is reacting, my lord, or rather acting on these complaints, my lord. But in my humble submission, this is a fit case for making the interim bail absolute, my lord. That is with regard to the wife, my lord, the first case.
page
28, my lord, that's the 35(3) notice. Sorry, my lord, this date is of FIR, my lord. FIR dated so and so. This notice date is not mentioned here.
no, page 28 is your notice for appearance by police.
No, this 35(3) notice, my lord.
Yes, Miss Sheila.
Lordship.
Nothing against her.
Exactly, my lord. We are not the one filing the anticipatory bail. They are. This is just a notice, my lord.
But
It states explicit. Lordship.
Miss Ahad, Doctor in Musica, Learned Senior Counsel for the petitioner. After the interim order is passed in this case, you have appeared before the IO.
My lord, as I submitted, we went to Khanapara.
No.
We could not appear before the Bagmara.
No, any
My lord, in fact,
any notice given to you
no, my lord.
or call made to you to appear before the IO
No, my lord. Nothing after that.
since the order was passed.
Nothing.
The applicant has never appeared, my lord. This is a notice under
You see, what happened is
lordship.
when an interim order is passed, it is incumbent. The order specifically says that if you have to cooperate with the IO as and when required.
Lordship.
Now it is incumbent upon the IO in course of his investigation, if somebody is required, for instance, the petitioner is required to appear for him, he is to make that call or issue notice, whatever. He has not done so. So it means that her presence is not required. We are talking about this specific petitioner.
No, my lord, as per the status report, lordship, at page 2 of Bagmara PS, lordship, if I may read,
Yes, sir.
that on 15/10/2024, along with accompanied staff left PS and proceeded for Jaipur, Rajasthan for attempting to arrest the accused person so-and-so of so-and-so address. On arrival at the residence of the accused person, he was not present. However, a notice of appearance, it's not 2022, my lord, it's a 2024 notice, lordship. Appearance was served through his wife, so-and-so. On received the application for extended absence in the FIR, she could not comply with the notice under section 35(3) due to health condition. First of all, they never complied, lordship. This is a 2024 notice, lordship, not a 2022 as placed here before this honorable
What I understand, lordship is asking about after the interim bail granted on 13 February, my lord, whether IO is called or summoned the petitioner number 1, my lord.
Lordship, failing to comply, then they come before this honorable court, lordship. 3 notices have been served and always pleading ill health, my lord.
No, notice
This
to
is
whom? I don't understand, my lord.
this is the same tactic.
I think my friend is confusing between petition number 1
I'm
and
not
2.
confused,
We
my
are on
friend.
petition
I'm
number
not
1 right
confused.
now.
Don't say that.
The query made is
Lordship.
after the interim order was passed, was any demand made on her to appear for the IO?
Lordship.
Forget about this notice. These have been issued earlier. Compliance of the same or not, you have to follow due process as as provided under the statute. That
Lordship.
is, a report has to be filed for the magistrate, and the order will be given to you.
Lordship.
No. Who has submitted that the petitioner that this court has taken cognizance of the prayer made in this petition and has at the first instant pass relevant order for grant of interim bail. Relevant order dated
13/2, man.
13/2 dated 13/2/2025 for interim bail to the petitioner. At this point of time, it is prayed that the interim bail granted may be made absolute. Ms. Angela Leonard Synergy, while opposing the prayer made, has referred to the status report filed by the IO. This Inspector Mukul Coach.
Lordship, kindly record it as Inspector Mukul Coach only, not the IO, Lordship, because it doesn't say IO, my lord, over here.
Filed by Inspector Mukul Coach of Bakmara Sadar PS, wherein in the latter part of the report a note has been made that a notice under section 35 under bracket 3 PNSS was served to the husband of the petitioner through her. But she has not complied with the same due to her health condition. In fact, the said notice was issued thrice to her,
Lordship.
which she has failed to comply with the same due to her illness. The report is not in view of the above. The Senior G has submitted that the interim bail granted to the petitioner may be vacated. On consideration of the submission made and on perusal of the said status report and the petition in hand, as far as this petition is concerned, as has been submitted by the learned senior counsel, a perusal of the papers on record at page 28 of the petition on procedural, it is seen that there is appended a notice for appearance by the police under section 35(3) of BNSS issued upon the petitioner herein. The said notice was dated 23/3/2022. Thereafter, there was no follow-up of the said notice. Yeah, I think notice was not
Notice is not dated.
not dated 23.
Very confusing also, even this one.
Not dated because
The FIR is dated 23.
you are directed to appear on 21/10.
21/10, my lord. So it is sometime in October or September, my lord.
So not from October dated 23. Notice was issued in 2009 from October, wherein the petitioner was directed to appear before the IO on 21/10/2024. Several months have passed by, and there is no report of what transpired thereafter. From the status report, it could be gathered that the petitioner has failed to appear before the IO because of ill health. As far as the provision of section 35(3) of BNSS is concerned, if the same is not complied with, if the direction issued is not complied with, it is incumbent upon the IO to file a report before the magistrate concerned and to be issued with an order even for arrest of the noticee. Nothing is found from the record that such a process has been undertaken or complied with. However, it is to be noted that the IO has also acknowledged the fact that the petitioner is ill and could not appear and could not comply with the direction issued under the said order, under the said notice. As regard the contents of the FIR, presumably for which the petitioner has been issued the said notice under section 35(3), perusal of the same. Where's the FIR?
Page 17.
Page
17, 17.
Perusal of the said FIR does not prima facie revealed any complicity of the petitioner as far as the allegation made therein are concerned. Next. In view of the above, this court is of the considered opinion that there is no case made out against the petitioner, that no case is made out against the petitioner herein. However, because of the reference made by the IO concerned, as far as her name is concerned, as regard her name, therefore it could be assumed that there's apprehension of arrest at any point of time in connection with the said aforementioned case, aforementioned FIR. Stop. The FIR in question would be Bagmara PS case number 4 under bracket 5 2022 under section 409/418/420 IPC. Next, accordingly, the petitioner, the interim bail granted to the petitioner here is hereby made absolute. Next, in the event of her arrest, she is to be released on bail on the following condition: that she shall not abscond or tamper with the evidence, that she shall appear for the IO as and when required. I think those, any specific condition you want to impose?
Lordship, she has been served notice just as a witness, my lord, over here, just to take her statement. I'm quite surprised by the apprehension of arrest, Lordship, but anyway, nevertheless,
Whatever the
Lordship.
case, if the IO requires her, anytime she can be summoned.
Well, Lordship, with the condition that she strictly comply with the notice issued, Lordship, they are not cooperating with the investigation at all.
The condition is there.
The only reason why I'm not strongly objecting to this, the instant matter, Lordship, is because her notice is just for
Exactly.
statement, Lordship.
Because nothing is on record
Exactly.
as to what. But anyway,
we have to be fair, Lordship. It's just for statement.
let her comply with the direction of the, the direction of the IO as and when required.
Lordship.
I can take to borrow itu condition 20,000.
Item number 6.
But as far as number 6, my lord,
This is with regard to
the husband, my lord.
no which
Same
case?
case, Bagmara.
Oh, come on.
The main accused, Lordship.
My lord, here I'll point out few documents, my lord. Page 14, my lord. This is where the business transaction started between these people, my lord.
Yes.
And my lord, this is dated 22nd August 2007, my lord. This is about 18 years back. The date you'll also will find at page 18, my lord. At the bottom, this 22nd day of August 2007 at Bagmara, my lord. So, my lord, by this agreement, this is general power of attorney, my lord. So, by this agreement, my lord, on a certain consideration, the accused person was allowed to, given the power of attorney, to run the bonded warehouse by the complainant, my lord. The complainant is Chinkame Moomin, my lord. Lords will see. Now, my lord, page 19, Lordship kindly comes on. After running it for 11 years, my lord, the complainant revoked the general power of attorney, my lord. Now, in para 3, I'll just take a lordship to that, my lord. No, now all that, by this deed, I cancel the said general power of attorney absolutely and completely and revoke all powers or authority thereby and then given to him by before revocation, either expressly or so basically by this, the power of attorney was revoked, my lord. So, after that, what he does, my lord, page 21, lordship kindly sees, my lord. The complainant appoints another person, Rajesh Bisukarma is the person to run the bonded warehouse, my lord. Now, my lord, before that, my lord, page 20, lordship kindly sees, my lord. Page 20 may not be necessary, my lord. Page 25, my lord, this is important, my lord. The complainant gives the certificate to whom it may concern. This is to certify that Gopal Krishna Goat has no liability or due towards the business that Mrs. Planet Bonded Warehouse, Bagmara, and officially released from all his dues. This is signed on 1st September 21, my lord. Now, my lord, it appears, my lord, till this point of time, there is a bona fide handing over, taking over, all business deals settled, my lord. Now, suddenly, what happens? We don't know. Then they filed in 2022, they filed an FIR, my lord. The FIR lordship is seen at page 26 in this case. The same FIR I have read in the earlier case, my lord. And it only says that some outstanding and payment of taxes are dues, and so filing of civil suit will not suffice, and that is why police intervention is required. The phrase used, my lord, police intervention, as if it is surgical intervention is required, my lord. What we talk, but why police intervention is required in a civil dispute, my lord? Now, my lord, and then this FR is of 2022, my lord. We are in 2025 now. For 2 years, they are okay. Police is also okay. Nothing so serious, my lord. Suddenly, then what happens, my lord? And lordship, I'll place some more documents, my lord. At page 36, your lordship will see. Excise Department issues a notice, my lord, at page 36.
Yes.
To Planet Bonded Warehouse. This is concerning this warehouse, my lord. Now, what it says, my lord, with reference to the subject cited, you are hereby directed to make payment of ad valorem duty against the shortage of IMFL, beer, wine, etc. with physical stock verification done on 13/4/22, my lord. Now, petitioner left in 2021 itself, my lord. The verification is done on 22, and monthly stock statement submitted by your bonded warehouse of August 21, which is amounting to rupees 84 lakh rupees, something. So, there is a requirement of paying 84 lakh rupees tax, my lord. And this is also pertaining to the period after, because he left in 2018, my lord. I pointed out the petitioner is out from the business. 18 to 21, maybe the complainant himself is running it, my lord. I am not sure about that. 21, this Vishwakarma gentleman, he comes in, my lord. And if all are post 18, my lord, after the petitioner is out from the business, my lord. But in spite of that, my lord, at page 37, your lordship will see the accused person pays 3,21,000. This is addressed to proprietor Chinkami with the same complaint, my lord. With reference to subject, I have the honor to inform that I have already paid the amount of rupees 321 lakh to Bagmara Municipal Board, Southwest Province, Meghalaya for the year July 21 to March 24. This is for your kind information. In spite of that, he pays that municipal payments, my lord. Now, page 40, my lord. Page 50, 59.
Yes.
No, my lord. Even after that, several payments were made, my lord. Your lordship will, that your lordship will find from page 58. 55 also, my lord. 40 lakh rupees was paid.
Paid by whom? By the. It was a petitioner.
Paid by petitioner, my lord. I'll just take your lordship to
page 68. We issued a check also in 2023. This much. Then this is the entire breakup of it.
page 69 is the entire breakup, my lord. Total details of how much payment the petitioner has made, my lord. What I'm trying to submit, my lord, these are essentially commercial transactions, my lord. They say that they are entitled to some more money from me. I deny, and then they seek police intervention, my lord, in the matter. Now, in these circumstances, my lord, 35(3) also comes into picture, my lord. That is one aspect of the matter. And looking at the subsequent development, my lord, as on today, there are 5 cases against us. 5 cases, my lord. 3 under 420, my lord. 1 under POCSO and 1 under Prevention of Corruption Act. 6 cases. Now, at this age, my lord, if he has to run entire Meghalaya, my lord, just for attending the IOs, my lord. And for what offence, my lord? This is not some National Security Act crime or some I've done some terrorism act, my lord. That they'll issue a lookout notice, my lord, for me. In how many occasions Meghalaya police has issued lookout notice, my lord? And what I heard from the government advocate on the last occasion, the police has gone to Jaipur 6 times, my lord, for this case.
Not 6 times.
That's what was submitted.
6 times.
My lord, for 420 case, my lord, 420 is essentially commercial transactions, my lord. These are private offences. And for redressing the grievance of 420, my lord, how many times the Meghalaya police has gone to Jaipur or to South India, my lord? Well, here the problem is that the complainants are bigwigs, my lord. They are all bonded warehouse owners, my lord. Your lordship aware, bonded warehouse owners have a lot of clout, my lord, in the government, and that is how they are pressurizing the police just to harass me, my lord. So this is on the merit of the case, my lord. The second aspect, my lord, what the grievance we had raised, can an accused person be transferred by one police to other police, my lord? In compliance of the orders passed by your lordship in Khanapada case, he goes to appear before the IO, my lord. IO's election duty or what duty, I do not know, my lord. That only the report can say. He is made to wait till evening, my lord. The 2 lawyers who accompany, they snatched their phone also. The lawyers somehow got back the phone by late night, my lord. They ran away to Jaipur and Delhi from wherever they came, my lord, apprehending that even they will be arrested, my lord. Now, Tura police comes, my lord, in connection with the POCSO case, lifts them from there without any permission from the court, my lord. They take it, keep him for how long, for how many hours or days, my lord. Then they register another case, my lord. Again, a new 420 case, my lord, in Ampati. My lord, can that be permitted, my lord? We are a society ruled by law, my lord. Can police transfer an accused person from one jurisdiction to other, or one district to other, my lord, without any permission, any leave from any court, my lord? My lord, this is one thing they'll have to justify. They'll are answerable for that, my lord. If they could be detained in Khanapada till next morning, my lord, in police station, why were they not produced before Khanapada police station? That's the first question, my lord. Second, if they were arrested in connection with POCSO case, why they are not produced before the POCSO court, my lord? And in the meantime, because we filed a habeas corpus, my lord, before the division bench, then they found themselves cornered, my lord, and then they produced him before the Ampati police station, my lord, in connection with the 3rd case. My lord, we will kindly appreciate the conduct of the police, my lord. My lord, in fact, whether I should submit that or not, because he is facing threat of life, my lord. But anything can happen, my lord, if he goes and reports to police. So, my lord, why I submitted on subsequent development, my lord, only to convince your lordship that it is not that he is trying to evade anything, my lord. In proper compliance with your lordship's order, he went to Khanapur, and after that, how he is treated, my lord, as if he is a football, my lord, from one player to other, from one jurisdiction to other jurisdiction, my lord. Tura, then Ampati, which police comes, and can police hand over one accused person without the permission of the court to another police of another jurisdiction, my lord? These are the serious questions they'll have to answer, my lord. These are absolute violation of the most cherished fundamental right under our constitution, my lord. This is Article 21, my lord.
You see, all these issues have, you cannot take them, comprehensively. It has to be, in isolation. Well, there may
My lord,
be
for that we'll seek legal remedy, my lord. For that we'll
change of circumstances,
my
no
lord.
doubt.
My lord, change circumstances, they are trying to impress on lordship that we have not complied with the order, my lord. That is why I am submitting, these were the circumstances because of which we could not comply, my lord. My lord, he is a senior citizen, my lord. There is no question of his evading or doing anything, my lord. But if they want money, my lord, if the accused person does not have money, it doesn't mean that they'll hang him just like that, my lord. They are commercial. They get a civil court decree, my lord, execute the decree, sell his property, they can do whatever they want to do. But they can't adopt this kind of way, my lord, for recovery of amount from a person, my lord.
Yes.
Lordship, if I might take your lordship to the extract of the case diary, lordship, at Annexure 8 of Baghmara.
Annexure
8, my lord. My lord has it.
Yes.
Notice under section 91(1) CRPC.
It would have been better, if we had done the pagination.
Lordship, I apologize, lordship, but on that day we had submitted it to the court, lordship. We had just received it in the morning, my lord. I apologize. May I assist your lordship?
But only one aspect I missed out, my lord. In Ampati case, my lord, where he was arrested in the last case, my lord, the court, and that was a regular bail granted after arrest, my lord. So lords will take into consideration that with the same offences, my lord. In one case, he is on regular bail, my lord, after arrest, my lord. In one case, absolute interim bail has been granted. So these are the two cases left, my lord. Khanapada and.
Where's the order?
If I may read, lordship.
Yes.
Notice under section 91(1) CRPC, reference Baghmara PS case number 43/2022 under section 409 IPC 19 September 2023 or dated 2023. To the Superintendent of Taxes, Circle 2, Tura, West Garo Hills, Tura. Whereas a complaint has been lodged by so-and-so, a license holder of Planet Bonded Warehouse, Baghmara, that the accused, a resident of so-and-so, has given the power of attorney to operate the said bonded warehouse. As per the agreement signed in the power of attorney, the payment of taxes to the government as mandated was to be done by the accused person. But he violated the terms and conditions laid down in the power of attorney by avoiding payment of taxes in favor of Planet Bonded Warehouse to the government with effect from lordship to 2007 till 2021. By doing so, Shri Gopal Kumar Gaur has committed a serious offence of criminal breach of trust, for which he is liable to be imprisoned, which may extend to 10 years with fine. Whereas a cognizable case has been under above referred now case number has been registered against Sri Gopal Kumar Gaur, and hence tax liabilities in favor of Planet Bonded Warehouse with effect from 2007 till 2021 is required for the interest of the case. Therefore, as per the provision under section 91(1) CRPC, you are required to furnish the tax liabilities in favor of Planet Bonded Warehouse, Bagmara, with effect from 2007 till 2021 to the undersigned within 7 days from receipt of this notice. You may furnish the required details sans personal appearance as per the provision under section 91(2) CRPC with prior information to the undersigned. My lord, what your lordship has been taken across is yet to be verified, lordship, with regard to the power of attorney and how the same was null. Lordship, what remains is that there has been evasion of payment of taxes, my lord, and the amount has accumulated, and this is from the year 2007, lordship. So when it comes to the fact that what has been submitted is a civil dispute, my lord, this is a criminal breach of trust. That is why the investigation team has to take up steps accordingly, lordship. And for that, lordship, with regard to Bagmara case, we have given the status report, lordship. They have not complied, number one, they have not cooperated with the police. Number two, lordship, somebody is confused. The police personnel never went to Jaipur 6 times. Is a one time, as is very evident in the status report, lordship. So for that, lordship, there is a clear criminal antecedents, I would say, lordship, because this is 2007 to 2021, and the allegations are quite serious, lordship. And over here also, the accused person, this accused person in this matter, lordship, has not cooperated with the police. Why should they be given anticipatory bail time and again, my lord? They should not be granted, because it is for sure they will violate the conditions as they had done so with the other case of Bagmara, of Tura, lordship. So on these grounds, lordship, I strongly object to any order granted in favor of anticipatory bail to the accused person. Lordship, the police, we have to do our job. The complainants running from pillar to post, lordship, because now the onus is on her to pay the tax, lordship. Lordship, kindly allow the investigation team to do its job. Coming up with apprehension that they may lose the apprehension that they may lose their life. We are not a police state, lordship. I mean, like, this is very serious allegations given to the state, lordship.
There is no question of stalling investigation,
lordship,
or even preventing investigation. That is not the purpose of any order, that is, any bail order for that matter, generally.
But they violated, my lord.
Because there is always, you have noticed in the previous order also, I have made it very clear that the person concerned is to cooperate with the IO.
Lordship.
So there is no question of stalling or preventing the IO from carrying out his duty.
Lordship.
If, as I'm just referring to the other case also, as far as the wife is concerned,
lordship,
if she, let's put it this way, she fails to cooperate with the IO, then a proper report can be filed, even approaching this court or the trial court for that matter, for cancellation of bail.
But lordship, these two cases cannot be on the same footing, my lord. They cannot be on the same footing.
I'm talking about general principles. Talking about general principles.
Lordship.
So as far as your apprehension is concerned, that investigation will be stalled, I don't think that's that will not stand.
But lordship, kindly do not place the previous case and the instant case on the same footing, lordship. No, the previous case is just as a witness, lordship. Over here, he's the main accused person. Tax evasion, lordship, for more than 20 years now. I mean, like 15 years now, lordship. Lordship, these are serious grounds, lordship. Anticipatory bail will be granted again, lordship. The same thing will happen as what happened last year. And we are made to run from here to another jurisdiction, lordship, just to secure the appearance, and that also they are not cooperating, lordship.
That we will comply, my lord. If we can't comply, they are always at liberty to approach this one.
Lordship, despite such a submission, I am strongly objecting to any anticipatory bail to be granted, lordship. based on the antecedents of and the behavior of the accused person since last year. With regard to, I'm talking only about the court proceedings, Lordship. What is determined to be prima facie is the job of the investigation agency, Lordship. But before this Honourable Court, Lordship, look at the conduct of the accused person.
Heard Tuan Musika, Learned Counsel for the Learned Senior Counsel for the petitioner was submitted that this court on prayer made by the petitioner in this instant petition had by the order dated 13/2 2025 passed an interim granted interim bail with the direction that the petitioner herein would cooperate with the investigation and to appear before the IO as and when required. Again, here also, when have you called upon the petitioner to appear before you, before the IO?
Lordship.
After passing of this interim order?
After the passing of this interim order, Lordship?
Yes. This is 13/2. That status report.
Lordship, after the passing of this order before this Honourable Court, Lordship, the a copy of this order was forwarded to the CJM, Lordship, by the Joint Registrar Listing, High Court of Meghalaya, Lordship, informing them of the interim bail, Lordship. Thereafter, Lordship, because of this, Lordship, from 13th of Feb, since the same was interim, Lordship, it appears, Lordship, that I do not have the updated documents with me, Lordship. But the interim was forwarded by this Honourable Court,
See
Lordship.
how the process goes.
Lordship.
An order was passed by this court granting him interim bail
Lordship.
with certain directions, particularly to appear before the IO as and when required.
Lordship.
Because that would be, in course of investigation, he would be required. Now it is incumbent upon the IO to call upon him to appear on certain dates, certain point of time. It may not be in writing, it may be by a telephone call, whatever, but that has to be reduced in writing in the report of the IO. So that has to be established first.
Lordship, the order was passed on 13/2, Lordship. Till then, Lordship, the IO was not aware of the whereabouts, Lordship. It was only on the 16th when they appeared at Khanapara, Lordship.
Why would he not be aware of the whereabouts?
Because they had even gone to Jaipur, Lordship, one time. They were not present over there.
It is the duty of the IO to locate his situation. I believe it would be incumbent upon the IO to have his phone number at least to contact
Lordship,
him. How do you communicate the
Lordship, it's
person
very
who has
clear,
been-
Lordship, the report given, Lordship.
He will not voluntarily come.
No, Lordship, the calls have been made, Lordship, as per the report given with regard to
Exactly. That's what I wanted to know. Where is
Lordship.
the
that.
indication?
Lordship, as per their travel to Jaipur, Lordship, it's very clear, Lordship.
Where is it written that he has? Where is the report?
Lordship, what I'm talking about is what had transpired on 15/10/2024.
We're not going back. We are not going that far back.
Lordship.
Just answer the query as on 13.
Lordship, from what has been updated, Lordship is not there. But Lordship will, for 3 days, Lordship, will this be a ground for granting them anticipatory bail in view of the several offences given to them? Let them cooperate, Lordship.
Forget about the offences. That is a different matter altogether. It has to be proved. It has to be investigated. If the offence is grave or not, that is not the concern of this court. Concern of the court, as far as bail jurisdiction is concerned, is only to ensure that the accused is present as and when required. That's number one. That he should not be a flight risk. That I'll come back to the same thing, that he should cooperate with the IO. But it is incumbent upon the IO to elicit that cooperation. If there is nothing on record that he requires him to come before him, then what can we do? It means he's not at all wanted. Not at all wanted in the investigation. I mean, for the time being.
It's because of his appearance before Khanapara PS that Bakmara and other jurisdictions became aware of his presence, Lordship.
Miss, you have not answered my question. As far as the Khanapara case is concerned, is it in one of these petitions?
But Khanapara also listed today, my lord.
Is it today? So we'll come to that.
Lordship.
As far as Khanapara is concerned,
Lordship.
that would be a different thing altogether.
Lordship.
Because there he has appeared before the IO, maybe on being called by the IO. But like I said earlier, see, let us go. You see, one case at a time. Otherwise, it will be very confusing for this court to pass, a comprehensive order. Gunung Toko? It is the further submission of the Learned Senior Counsel that admittedly the petitioner could not appear before the IO in this case, since circumstances arose whereby on his appearance before the IO at the Khanapara police station, Riboi district, in connection with another case involving the petitioner hearing, he was detained by the police of Tura police station, who had in the meantime come to the said police station in connection with other cases filed against the petitioner at the within the jurisdiction of Tura police station, and accordingly he was taken by the police to Tura, and subsequently from Tura he was taken in custody and ferried to Ampati police station. Ampati ke southwest Garu Hills, in connection with yet another case and was formally arrested at Ampati. Next, therefore, as far as this instant case is concerned, the petitioner, as pointed out, could not appear before the IO. It is, however, the submission of the learned counsel that if the interim bail is made absolute, he will cooperate with the IO and will abide with any condition to be imposed by this court. Ms. Anjishila, learned CIG, has strongly opposed the preamute herein and has submitted that the allegation made against the petitioner are serious in nature, even though relevant section of law include section 420 IPC. The fact of the matter is that the petitioner, as manager of the concerned bonded warehouse, had failed to pay the required taxes to the government with effect from the year 2007 to 2021. As such, in course of investigation, police personnel had even, since the petitioner has failed to appear before the IO, the petitioner has, the police personnel had even proceeded to his known place of residence at Jaipur in the state of Rajasthan to apprehend him, and yet could not do so till he finally voluntarily appeared before the Khanapara police station. In view of the conduct of the petitioner and the severity of the offence alleged, the learned senior GA has cited that the prayer made in this petition may not be allowed. This court has considered the submission made. As far as this case is concerned, the learned counsel for the petitioner, learned senior counsel for the petitioner, has referred to page 28 of this petition, wherein is found the extract of the FIR file before the in charge Bakmara PS, resulting in the registration of the said Bakmara PS case. Ngalaan yang tu Bakmara PS case anjo. Yang ni, resulting in the registration of Bakmara PS case number kanum tu. Check tu under section tu yang ni atau the allegation of the complainant therein is that the petitioner who has been running her bonded warehouse at this bonded warehouse is at Khanapara. Sorry, at Bagmara.
Bagmara. My lord, the typed copy is also there, page 33, my lord. Your lordship, friends.
And really deciphers too.
It's a small, my lord. I will give him typed copy. Page 33, my lord.
Who has been running her bonded warehouse at Bagmara till the year 2021, from 2007 till 2021, had issued by the concerned department his paragraph tu masdang tu yeah, the next one. It is to be noted that the FIR was filed in the year 2022 and investigation is still ongoing. No charge sheet has been filed.
No.
Charge sheet is yet to be filed. Now, what would concern this court is to look into the conduct and antecedent of the petitioner, the accused, as far as this case is concerned. Records have revealed that since the last order passed by this court on 13/2/2025, the IO concerned has not made any effort to require the attendance of the petitioner before him, since nothing on the call. It would be that as it may, it is incumbent upon the IO to be diligent in his investigation, and from what has been submitted by the learned senior GA, that the conduct of the petitioner is such that not only is he involved in a matter which is serious in nature, but also that his attendance whenever required could not be ascertained, prompting the police to even go to his native place.
Residence, my lord.
Residence. That's not his native place. He
Lordship,
may not be from there.
Lordship. maybe not Lordship, but that is residence in Jaipur.
He's resident at Jaipur. The submission made by the landed CNGA would be relevant if a concerted effort has been made by the IO as observed herein above. This court at this point of at this juncture would refer to an authority by the Honorable Supreme Court as far as bail matters are concerned, wherein in the case of Sanjay Chandra versus CBI itu itu ke citation mo at para 21 of the same, the observation made, the following has been observed. Under the circumstances, this court, on consideration of the facts and circumstances, this court, on consideration of the situation as it is, inclined to allow the petition made herein. Accordingly, the interim bail granted is hereby made absolute. The petitioner is directed to be enlarged on bail on the following condition: that he shall not abscond, that he shall appear for the IO, that he shall not leave the jurisdiction of India, that he shall surrender his passport before the IO, and would require the permission of the IO if he is to travel, if he is required to travel abroad during the pendency of the case. And that he shall appear before the IO as and when called for. Needless to say, any violation of the above condition would allow the prosecution to file an appropriate application for cancellation of the bail, either before the trial court or before this court. Took a bail set at 50,000.
My lord, the condition imposed as and when required, lordship, the same exercise will prevail, lordship. Notice will be issued, he'll disappear somewhere else. Kindly, my lord, if I may pray, lordship, let his presence be secured on a particular date, lordship, by this honorable court.
Whatever you say.
Before the IO.
As a condition, the petitioner is also to give his contact number and place of residence to the IO immediately, in view of the ongoing investigation. The petitioner is directed to, in the first instance, the petitioner is directed to appear before the IO.
Today is the 3rd, lordship. Let it be on Friday, lordship. He has nothing to fear now, lordship.
I may pray for 11th, 12th sometime.
Let it be on Friday, lordship.
Or within a period of 10 days, my lord.
No, lordship. Let it be a fixed date, lordship, not within a period of any certain amount of time. Let it be on Friday, Lordship.
Today is
He
third.
has anticipatory bail in his favor now.
Yeah, 7th. Fair enough.
The third is 7th. Where is it now?
It's a good 4 days away, and they would have number and
They have to
everything,
put 10th or
Lordship.
11th, my lord. 7th.
Lordship, I'm insisting on the 7th, Lordship.
It hardly will make any difference.
You
It's
got what you
20
want now. Let
22
me get what I want also. Let it be
22
on the
FIR.
7th, Lordship.
Logistics, we will booking tickets and all that.
No, Lordship.
10th will not harm anything.
Let it be on the 7th, Lordship.
What is it's good, you can do online. Everything now is online. You can always come.
Much obliged, Lordship.
7th only.
On the 7th. On the 7th.
Let it be on.
My lord, only worry, my lord, another FIR is there, my lord.
That is see.
As they come, they'll keep on coming, Lordship. Much obliged, Lordship.
Every time.
that will be a that will be a different aspect of the matter altogether. Nothing that is, if it is within the records of this court, it will be taken care of. Otherwise, you can't come now and say,
But he goes to appear Bagmara, my lord, and then he's picked up by Khanapara police in connection to corruption case, my lord.
Lordship, they're already pleading for the next matters, Lordship. Let it come up at that time. You're taking advantage of the court's decision just now. Much obliged, Lordship.
Item number 7.
just a moment, Miss. There are other matters relating to him.
Lordship.
We'll take it up now.
Now, Lordship.
Yes. Otherwise, it get disrupted. I think this is item number
13 and
13
15.
and 15, my Lord.
13 and 15.
Lordship.
And this 14. Not even this.
This is another matter, Lordship. This is a regular bail application.
Same.
No, Lordship. It's not connected with the instant matter, Lordship.
14 is different, my lord.
We'll take up 13 and
Gotcha.
15 now. Oh, this also anticipatory bill.
My lord. But here also, Lordship will please to grant interim bail, my lord, on 18th, my lord, 18th of February. Now, since he's on bail in 3 cases, my lord, one regular, 2 anticipated, my lord.
This is the Torah case or
This is Khanapara
This
case.
is Khanapara, Lordship.
They also pertain to
what
bonded
is the
warehouse.
allegation?
Lordship,
I'll take a Lordship to
there
the
are
FIR,
many
my lord.
bonded warehouses being run by the accused person, Lordship. Many jurisdictions, Lordship. And all complainants are different, Lordship. It's not the same complainant.
Well, the FIR starts from page 19, my lord. So, what, page 17 is original FIR, my lord. May I read, my lord? This is 9th July 24, my lord. It says, my lord, with reference to subject cited above, I, Srimati Suchana Sangma, the proprietor of Mrs. Suchana Bonded Warehouse at 9th Mile, Varudua, so and so, so and so, has appointed Sri Gopal Krishna Gaud, son of so and so, so and so, so and so, as my manager to look after the affairs of the warehouse under his full control since February 2016 till 11 June 24. However, in my surprise visit to the warehouse on 12 June 24, I have found loss of misappropriate and also mismanagement of the warehouse and other official documents also suspicious and unknown bank transactions. So I called my chartered accountant for the audit. There we found minus in stocks, and comparing with excise register, the stock were huge difference also. Some of huge amount were misused by the aforesaid person and also forged my signature to access the bank and offer official documents. Therefore, in this ongoing audits, his son Rahul came to warehouse office and stolen the laptop and file data and the data where all the information of warehouse were available. And also I have given them sufficient time to clear all the doubts of stock, sales, purchase and bank transaction, but they failed to do so. Mr. Suchana bonded warehouse have vehicle to transport the goods to retailers. Among all the vehicles, one vehicle is missing, the registration number so and so, which Gopal Krishna Gaur used for office and personal purpose. The above act of Sri Gopal Krishna Gaur amount of cheating, misappropriation, fraud, forgery and stealing, and also cheating a person belonging to a scheduled tribe. To the best of my knowledge and understanding, Sri Gopal Krishna Gaur is fully liable and answerable to pay the liabilities and dues against any bond. Therefore, in the above premises, it is my humble plea to your esteemed department to take. Now, my lord, here are lots of the substance, the crux, my lord, is that he is liable to pay. In the previous paragraph, to the best of my knowledge and understanding, Sri Gopal Krishna Gaur is fully liable and answerable to pay the liabilities and dues against my bond. Now, this was registered as case, my lord, under section 381, 408, 120B, 417, or the usual sections, my lord. And that's how the matter. After your lordship was pleased to grant interim bail in this, my lord, when we went to appear, that is before your lordship, my lord, that the Tura police came, then he was taken to Ampati and this how, my lord.
When you went to appear
My lord.
before the Khanapara,
My lord.
your statement was taken.
No, not taken, my lord. Rather, they are not interested in taking my statement, my lord. They are more interested in calling the police from Tura, my lord, in regard to POXO case, my lord.
That's a different thing.
My lord. And Khanapata IU, my lord, I'll just place the, because the document by which this forwarded him for medical examination, my lord. This is signed by Khanapara OC, my lord, sending the petition for medical examination, but in connection with Tura case, my lord.
Yes, so what do you make of it?
My lord, just to establish, my lord, that he went to Khanapara police station on that day, my lord. He met the OC. OC sends him to for medical examination. They don't record my statement, my lord, in connection with the case I went to appear, my lord. So, in my humble submission, my lord, we have, in this case, we went to comply with the interim order, my lord. Voluntarily, my lord. That also we were not called, my lord. My lord, we will fully comply with any direction, my lord. Your lordship pose, my lord. Because passport is only one, because that we will already deposit with Bakmara, my lord.
Yes.
Lordship. Lordship, I beg to...
This is the status report you have filed.
Lordship, no, Lordship. We have not filed anything, Lordship. This is the extract of the CD, my lord, which I am placing before this honourable court.
No. This comprehensive report.
Comprehensive report has been filed, Lordship. Extract of the CD has not been submitted before this honourable court, Lordship. And that is the comprehensive report, Lordship.
Yes.
Lordship, that is the one. But Lordship, the status report covers what has transpired in the GD, the case diary also, Lordship. May I read, my lord? May I take a Lordship?
Where is this one?
Lordship.
This.
In original, my lord. The status report. It's from SP Ribhoy, Lordship. Senior Superintendent of Police.
Yes, I'm just.
Lordship.
You're referring to this report dated 23rd February?
February 2025, Lordship. 23rd February 2025. It's on the first page, Lordship.
Yes.
Lordship, may I read, Lordship? Going to the first page, Lordship. The instant case was registered on 17th of July 2024 based on a written FIR lodged by Srimati Suchana CH Sangma of so-and-so address and is being investigated upon by UBSI so-and-so. The gist of the case, Lordship. The gist of the case is that the informant was the license holder of Sochana Bonded Warehouse at Khanapara, Ribhoy District, white license number so-and-so. She has been operating the said Sochana Bonded Warehouse at Khanapara since 2016. She officially appointed the accused person, namely Gopal Krishna Gaur, son of so-and-so, of temporary residence of so-and-so and permanent residence of so-and-so. On 12/6/2024, the informant, along with her family members, made a surprise visit to Sochana Bonded Warehouse, and when she checked the stock, it was found that goods had been distributed / supplied to the retailers, but there was mismatch with stock and government registered goods, as the register maintained in Sochana Bonded Warehouse was not tallying with the goods supplied to the retailers. It was also informed that Gopal Krishna Gaur had, that is the accused lordship, had distributed / supplied the goods to various retailers, and the sale proceeds, which is supposed to be deposited in the account of Sochana Bonded Warehouse, was being directly deposited in the personal account of Gopal Krishna Gaur. Also, the vehicle bearing registration number AS01EH1547 belonging to Sochana Bonded Warehouse was found missing. Lordship, this is with regard to the instant bail application. It was found that one Rahul Sharma, son of Gopal Krishna Gaur, manager, has taken cash amounting to 6,50,000 from Sochana Bonded Warehouse on 13th of June 2024, which is supported by the CCTV footage of the said bonded warehouse. It was also informed that the retailers, namely Messrs. VK Wine Shop Khanapara, Messrs. Nits Wine Shop Khanapara, Messrs. Happy Valley Wine Shop Khanapara, Messrs. Goodwill Wine Shop.
Just skip the.
Lordship, Lordship, the number of wine houses also matters, my lord, because
just tell me the number.
Lordship.
Can't go to
So,
easy.
Lordship, it'll be 1, 2, 3, 4. So it comes to a total of 11, my lord.
Yes.
Has been continuously paying and depositing the money in the account of Gopal Krishna Gaur, despite the instructions of the informant not to do so. And therefore, they are also liable in committing the offence, as they are hand in glove with Gopal Krishna Gaur for their monetary interests. Also, the staff members, namely Gopal Krishna Gaur, Rahul Sharma, his son, Madhusudan Sharma, Ram Nathan Nath, salesman, and Kamal Nath are involved in the case. During investigation, the witnesses were examined and their statement corroborated with the allegations made out in the FIR. During investigation of the case, the records of the said Sochana Bonded Warehouse were searched but could not be found. It is highly suspected that the documents might have been stolen or destroyed or concealed by Gopal Krishnan Gaur in conspiracy with others, including his son Rahul Gaur. Now, Lordship, we come to the tax liability suspected misappropriation. During investigation of the case, it is also found that there's a pendency of government tax amounting to 60,40,171 rupees only, which has not been paid. And it is highly suspected that Gopal Krishna Gaur, in conspiracy with others, including his son Rahul Gaur, had misappropriated the money. It was also found out that all the wine shops named in the FIR were run by Krishna Gopal Gaur in conspiracy with others, including his son Rahul Gaur, who in return shared the profit with the licensee. Further, the main salesperson of these wine shops was one of the named accused, namely Ram Ratan Nath, who collected the daily sale in the absence of the accused person. Ram Ratan Nath was arrested, and during examination, he voluntarily admitted that Gopal Krishna Gaur had told him that he will be sending someone soon from Rajasthan to assist him in managing these wine shops. Seizure of the wine shops, Lordship. During the course of investigation of the case, the wine shops mentioned in the FIR were seized on 27 July 2024 and kept under lock and key. The CCTV footage showing the accused, Rahul Gaur, entering the bonded warehouse was also seized accordingly. Lordship, then we come to the IO's first visit to Rajasthan on the 11th of August 2024. During investigation of the case, the IO personally visited Jaipur and sought police assistance from the local police station of Vidyadhar Nagar PS for the purpose of investigation of the said case to ascertain and verify the facts of the case. However, neither Gopal Krishna Gaur or Rahul Gaur appeared at the local PS in Jaipur. They were not found at the residence either when the IO visited their house with the local police on 11 August 2024. Lordship, this is the next paragraph with regard to non-compliance of notice. A notice under section 35(3) BNSS was sent to Gopal Krishnan Gaur and Rahul Gaur by registered post with a direction to appear before the IO of the case on 15 September 2024. The same was duly received by them on 9 September 2024, but they failed to appear in person. Instead, they sent representatives who informed the IO that Gopal Krishna Gaur was not in good health. There was no response from Rahul Gaur. Then, Lordship, they had filed an anticipatory bail application. Should I read that paragraph, my lord? Or
Not necessary.
not necessary, Lordship. So, Lordship, then there certain conditions were laid out in the first anticipatory bail, Lordship, and the conditions that were mentioned over there with regard to the accused person is that he shall not abscond and he shall appear before the IO as and when required. However, they never complied with the conditions of the court, nor did appear before the IO till date. Now, Lordship, comes the paragraph with regard to forged documents by the accused. During investigation of the case, Gopal Krishna Gaur and Rahul Gaur sent their signed statement via post along with documents, that is appointment letter signed by the informant dated 22/12/2015, power of attorney executed between the informant and Gopal Krishna Gaur dated 22/12/2015, new appointee agreement dated so-and-so signed by one Ram Pratap Nath and the informant authorizing him to manage the bonded warehouse from the said date. However, on showing the document to the informant, she strongly denied that such documents were prepared before her, nor did she recognize or know any person by the name of Ram Pratap Nath. Now, Lordship, there was a cross-verification of the forged documents with other accused persons. During investigation, it was ascertained that this Ram Pratap Nath was the personal driver of accused Gopal Krishnan Gaur. He was contacted over mobile phone, during which he informed that he does not work with Gopal Krishna Gaur anymore and that at present he is in Tamil Nadu working as a driver there. He also informed the IO that he has no knowledge of any agreement made before him and the informant at any point of time. On going through the bank statement of Sochana Bonded Warehouse, it was found that there were several money transactions to one bank account in the name of Ram Pratap Nath in the year 2022. However, the said person informed that his bank account was managed by Gopal Krishna Gaur only and he has no knowledge or access to that particular bank account. Also, the signature of witnesses found in most of the documents were found to be of the employees who had worked under Gopal Krishna Gaur. Therefore, it's highly suspected that Gopal Krishna Gaur has made these forged documents for the purpose of cheating. Lordship, on 1st of October 2024, the JMFC Ribhoi district had issued an NBWA against the accused person, namely Gopal Krishna Gaur and Rahul Gaur, which remains unexecuted till date. During investigation, Lordship, a lien of rupees 6 crores 60 lakhs 40,171 rupees and 74 paise, which was a tax liability of the said Suchana Bonded Warehouse, was placed on 30th of November 2024 on an ICICI bank account number so-and-so in the name of Rukmani Jewelers, operated by Rahul Gaur and his mother, namely Kaushlia Gaur, to compel their appearance of the accused persons. Kaushlia Gaur is the wife of the accused, Lordship. Then we come to the IO's second visit to Rajasthan on the 20th of December. During investigation of the case, the IO again personally visited Jaipur, Rajasthan, and sought police assistance from the Rajasthan police for the purpose of investigation of the case to ascertain and verify the facts of the case. However, neither Gopal Krishna Gaur nor Rahul Gaur appeared at the local PS in Jaipur. They were not found at their residence either when the IO visited their house with the local police on 20th of December 2024. Then, Lordship, they had applied for a second bail application before this honorable court, which was again granted to them, Lordship. Lordship, between the second bail application. However, between 10th of December till 14th of February 2025, there was absolutely no cooperation from the above named accused with the IO, which is clear from the facts stated above, Lordship. Lordship, the visit of the accused persons to Khanapara station, wherein they had appeared at Khanapara PS on 16 February 2025 at 60:20 hours and stated their wish to meet the IO. Accordingly, the IO, who was in charge of Rani Jirang OP, which is located approximately 30 kilometers away, was informed. The IO stated that he was occupied with law and order duty in connection with KHADC election 2025. He will be arriving after some time. Then the receipt of WT signal from Tura Women PS, Lordship. So, Lordship, they had received the WT from, it's better I read this also, Lordship. Meanwhile, at 5:50 hours, 17:50 hours, a WT was received from Tura Women PS by WT number so-and-so dated 16 February 2025, requesting to detain Gopal Krishna Gaur as he is wanted in connection with Women Tura PS case number so-and-so, with regard to certain sections of BNSS, read with section 18 POCSO. Accordingly, the above named person was sent for medical examination. Again, at 19:24 hours, a WT was received from Tura Women PS, requesting to detain Rahul Sharma as he is wanted in connection with Tura Women PS case number so-and-so of certain sections under BNSS and section 18 of POCSO. Accordingly, the above named person was sent for medical examination. At 19:30 hours, Gopal Krishna Gaur returned to Khanapara PS after medical examination, wherein he was found to be kept in custody. Accordingly, he was detained over to Tura Women PS team, which was already underway. Similarly, at 20:30 hours, Rahul Sharma returned to Khanapara PS after medical examination, where he was found fit to be kept in custody. Accordingly, he was detained for handing over to Tura Women PS team, which was already underway. Lordship, the next paragraph is what had already been read before this Honorable Court, which I will read again now. Between 20:30 hours to 2100 hours, Lordship, both the accused persons named above offered a bribe of rupees 10 lakhs to the police officers on duty for helping them to let go without arrest and to help them to get anticipatory bail from the court. The same was recorded in the GD entry by GDE entry number 12 of so-and-so date at 2100 hours. In this regard, a cognizable case White Khanapara PS number so-and-so under section so-and-so of Prevention of Corruption Act 1988 has been registered and being investigated into. Lordship, everything is, all the supporting documents are there in the extract of the CD, Lordship. And with regard to the adding of sections, the concerned IO had already approached the JMFC and Reboy, Lordship, and at the extract of the CD, Lordship, at the last page, Lordship. This is the order sheet of the JMFC and Reboy.
Yes.
Lordship. CR put up today. Seen prayer for adding section so-and-so during the course of investigation. The accused have produced documents. This is with regard to the forgery, my lord. I'm sorry. This is with regard to the forgery. This has been added prior to the accused appearing before Khanapara PS, Lordship. These sections were added. This is with regard to 465, 468, 471. This is with regard to forgery, Lordship. 201, 419, 379 IPC, Lordship. So this is what has transpired with the instant anticipatory bail application, Lordship. It's a very detailed report, Lordship, on which there are strong grounds for objecting to the anticipatory bail pending before this Honourable Court, Lordship.
Yes.
Only two submissions, my lord. So much investigation has already been done, my lord, that why custody is required, my lord. That's one aspect, my lord. It seems that they are ready to file charge sheet, my lord. That's one aspect, my lord. Second aspect, my lord, the 4 bond-related cases, my lord. One is POCSO and one is Prevention of Corruption, my lord. As far as bond-related cases are there, my lord, 4 your lordship is protected as my lord. Only 1 case is left. Whatever conditions are imposed, my lord, we will fully cooperate, my lord. If your lordship require that we submit a bail bond also, my lord, we will do that, my lord. Though for anticipatory bail, it is not required now, my lord, after Supreme Court decision. But if your lordship desires, my lord, so that they do not evade, they may even be directed to furnish a bail bond before the court below, my lord. Because custodial interrogation is only for the purpose of investigation, my lord. What I find, my lord, they are even ready with the charge sheet, my lord. Investigation is completed, my lord.
We're not ready with the charge sheet, Lordship. This is just an extract of the CD, Lordship.
Yes, I think investigation is
Exactly, it's ongoing, Lordship.
So if they are required for investigation purpose, well, they'll cooperate, my lord. Any condition a lordship will put, will comply with that, my lord. To the extent even bail bond, my lord, will give bail bond also.
Lordship, kindly take into consideration nearly 7 crores of tax has been evaded, Lordship.
I do not know because.
And this is due to the government, my lord. This is due to the government. As has what been
but by
pointed out with
custody,
regard to the income tax notice, Lordship, which has been pointed out before this Honourable Court in the previous matter, Lordship.
So custody, the money cannot be, will not be realized, my lord.
But now forgery is coming, Lordship. Informant has declared explicitly that she had never executed the agreement. So did the driver, who said that his account was maintained by the accused person, Lordship.
Well, these are all matters of investigation, my lord.
Exactly,
But if
Lordship.
lordship
That's
is
why
protected in
anticipatory
3
bail should
cases,
not
my
be
lord.
granted.
Lordship protected in 3 cases, my lord.
Those
4th
are
case, my lord.
grounds, you see, those are grounds which can be made out when a charge sheet is filed.
Lordship.
When you find that prima facie
Lordship.
case exists against the, that of
We'll
course.
face the trial, we'll face the consequences if they violated, my lord.
Lordship, we have been deterred from investigating the case, Lordship. At this stage, Lordship, I strongly object to this bail application, anticipatory bail application. Everything is at expenditure of the state to go to Jaipur and come back empty-handed, Lordship.
My lord, in this case, we voluntarily went and appeared, my lord. Instead of
Only after interim was...
questioning me, my lord, they sent me to Tura and Ampati, my lord.
Because of the interim, they were never arrested at Khanapara PS, Lordship. It's because of the interim. They
But
came and
he was
appeared.
re-
And
he
we
was
never
there
arrested
for-
them.
He was there for investigation, my lord. And my lord, lordship may direct us to give bail bond, my lord, if they are not complying, because I cannot take that grant. Lordship may direct them to furnish adequate bail bond before the concerned CGM, my lord, within 3 days' time. So that they cannot evade, my lord. They fully comply with whatever license. This I am submitting voluntarily. In law, there is no requirement of giving bail bond, my lord. But I am submitting
That
voluntarily.
is only when you are arrested, then of course, because a bail bond will come.
But in this case, your lordship, I am undertaking, my lord, we will furnish a bail bond also.
But Lordship, there's already tampering of witness, Lordship, as has been read out by this Honourable Court. During investigation, Lordship, the records of the said bonded warehouse could not be found, my Lord.
Why didn't you record my statement when I went? Why did you send me something?
So that is the thing, Lordship. So it is known that further tampering will go on, Lordship. And the vehicle is also still missing till now, Lordship.
Police has enough power, my lord. Police has enough power. If they want, they can do it, my lord. If they don't want,
We are powerless if they don't cooperate, Lordship. We are at the whims and fancies, Lordship. We go to Jaipur twice, Lordship.
I have maintained, you see, right from the beginning, that the power of investigation lies solely with the IO. It is not for this court to spell out how you conduct your investigation. For you, the purpose is to make out a case, file a charge sheet, and make the accused stand trial. In course of investigation, if the accused or the petitioner for that matter fails to cooperate,
my lord.
you have pointed out, yes, see, that he has failed to appear before the IO, he evaded arrest or evaded appearance before the IO, even compelling you, or rather compelling the IO to go to Jaipur to look out for him in spite of that. But that is all, that's water under the bridge now. Because as it is, the present situation is, the petitioner has appeared, has come before this court seeking relief, and also, offering or rather tendering a commitment that he will appear. In the previous order, this court has given him, has directed him rather to appear before the IO concerned on a certain date.
Lordship,
if he feels-
Lordship, before that, my lord, there are 2 separate cases here and again, Lordship. One is with regard to the instant application. He was caught on CCTV camera taking that amount of 6 lakhs plus, Lordship. And now with regard to item number 15, Lordship, this is with regard to forgery, theft, then tampering of evidence, Lordship. These are 2 separate cases, Lordship. Lordship, kindly do not take them on the same footing against, as I had made my submission in the previous case, Lordship. How can they be granted anticipatory bail, Lordship? If any other case, Lordship, with regard to CCTV camera and CCTV footage was available, somebody stealing, Lordship, they would have been arrested immediately, Lordship. But over here, Lordship, taking advantage of, I will not go into that again, Lordship. They are coming up with so many petitions that at the end of the day, they are now coming that on the same footing. If bail has been granted in that one case, we will cooperate, Lordship, in the other case also. It cannot be taken on the same footing at all, Lordship. These are separate cases altogether. The only thing common is that there has been theft, misappropriation of money, and tax evasion, Lordship.
Well, as Lordship is directed in the other case to appear on 7th, my lord, in Kanapada will appear on 10th, my lord.
Lordship, I am strongly
Saturday,
objecting to
Sunday,
this
my lord.
present
And
application,
we'll even
Lordship.
furnish a bail bond, my lord, in this matter. If there's any apprehension that will not appear, at least.
Can you record my submissions, Lordship? Because these are very, very serious offences, Lordship. 7 crores, Lordship. Nobody can even dream of 7 crores, whereas this is just a tax invasion, my lord.
My lord, as far as FIR, there is no mention of amount, my lord.
This is during investigation, Lordship, and now they have come to know.
No, the complainant doesn't know how much is the
It's
amount.
because the status report has been called. That's why we are giving this information to this honorable court, Lordship. And the intent of giving such information, Lordship, is to prevent any anticipatory bail being granted to the accused persons, my lord. And Lordship, in the previous case, Lordship, Bakmara case, bail has been granted to the wife of the accused person. Now even her account is involved in this instant case, Lordship. Certain transactions have been made to her account, Lordship. So, Lordship, we cannot say somebody's innocent or this or that.
I mean, as far as investigation is concerned, you continue with your investigation and see. But the allegation, as has been pointed out, are very serious. This, you see, I can distinguish the allegation made here with the previous case. As far as those previous cases are concerned, there are, allegation of tax evasion, your conduct as far as management of the bonded warehouse are concerned. But here, there is a question of forgery, there is a question of theft, there is also the issue of using the company's vehicle. All those things are serious.
And there are 11 bonded houses involved, Lordship. 11, my lord.
Heard, Mr. Doctor. And Musika Leonard counsel for the petitioner, who has submitted that an FIR has been lodged against the petitioner. An FIR dated 9/7/2024 has been lodged before the Superintendent of Police, Rivoy District, wherein the complainant therein had made a number of allegations against the petitioner. Such allegation relating to tax evasion, relating to the tenure when the petitioner was in control of the management of the bonded warehouse of the complainant, and in course of such management he had caused evasion of taxes, fraud and forgery through in his personal capacity, as well as through his son named Rahul. The vehicle belonging to the complainant which was utilized by him during the relevant period, was also missing and the same has not been handed over to the complainant till date. Accordingly, on such complaint being made, The FIR was registered as Khanapara PS, case number 25 under bracket 7 2024 under section IQ section mo. As far as this matter is concerned, the learned senior counsel has submitted that this court had granted interim bail to the petitioner, and in the intervening period, the petitioner had approached the IO at the said Khanapara police station, but on the day, but on the, yeah, but on when did you go? 16. But on 16
Lordship.
16 February,
16 February.
on 16 to 2025, when he went to the said police station, instead of his statement being recorded, he was actually detained in connection with some other case which was registered by the at the Tura police station. And was subsequently taken into custody and sent to Tura, and from there was again forwarded to Ampati, Southwest Garo Hills, in connection with yet another case where he was eventually arrested. However, as far as the case at Ampati is concerned, on an application made, the petitioner was granted bail the next day. As far as this case is concerned, the learned senior counsel has submitted that the petitioner may be allowed to be enlarged on anticipatory bail with any condition to be imposed, even to the extent of furnishing of a bond, though the same is not required in law at this point of time. Next. Ms. Angela, the senior GA, has vehemently opposed the prayer made in this petition and has referred to the said FIR dated 9/7/2024 to impress upon this court that the allegation made therein are very serious in nature. Again, such allegation being that of fraud, cheating, forgery, and theft, to name a few. The learned senior GA has also referred to the status report filed by the Senior Superintendent of Police, Riboy District, wherein a detailed report has been filed giving the gist of the case of the prosecution, comma, the conduct of the petitioner, particularly his conspicuous absence in course of investigation, to the extent that the police had to go to his known place of residence at Jaipur in the state of Rajasthan to apprehend him, but to no avail, since he could not be found there at the said place. This, according to the learned senior GA, would reflect the bona fide of the petitioner, inasmuch as there is no intention on his part to cooperate with the investigation. The other aspect of the investigation is that there is found an amount of about 6 crores or so, about an amount of more than 6 crores in government tax due and payable, which has not been paid by the petitioner. And also the fact that he is in a conspiracy with a number of with about 11 owners of various bonded warehouses situated at, these are all situated in Ribhoi,
Lordship, all 11 bonded warehouses.
situated in Ribhoi district, which,
Lordship, those are wine stores, Lordship.
oh, wine store,
Lordship.
oh, sorry, owners of wine store, which has compounded the complicity of the petitioner herein, as far as this case is concerned. There is one, statement you have made, non-compliance with condition imposed by, but you have not referred to which order he has not complied with.
Non-compliance, Lordship. This is with regard to anticipatory bill 28.
Again, you have not given page number here.
Sorry, Lordship, this has come directly from the office of the SP, my lord. I did not dare to put in any numbers there, since it's the original copy, Lordship.
You see, as mentioned earlier, Honorable has granted anticipatory bail to Gopal Krishna and Ravi for the following condition: that he shall not abscond, that he shall appear before the IO as and when required. However, neither Gopal Krishna Gaur nor Susasu has appeared before the IO till date. But you have not mentioned which order.
I'm sorry, my lord. Where were you, Lordship? I'm also a bit lost without the page numbers, Lordship. Sorry, my lord.
Ini. I just want to confirm the
Lordship,
date of the relevant order.
Lordship, it appears that this will be with regard to the interim anticipatory bail granted by this Honorable Court, Lordship. Lordship.
What date?
That will be of 12.
On the 22nd of October 2024, in anticipatory bail number 19 of 2024.
Is it so? See, you're not clear.
Lordship, I'll have to verify that, Lordship. 28th of October, Lordship. Yes, Lordship. The order granted by this Honorable Court in anticipatory bail number 19 of 2024, Lordship. On the condition that he shall not abscond and he shall appear before the IOS and when required, Lordship.
This is also with regard to this Khanapara PS case?
Lordship.
How many? This is.
This was withdrawn and
That was the first round of anticipatory bail application.
That was withdrawn subsequently.
Lordship.
That bail application was withdrawn.
withdrawn.
Withdrawn and
Lordship, yes, Lordship. They had
order
prayed for
withdrawal will be
withdrawal.
next filed. We managed the order
Liberty to
withdrawal.
file a fresh, Lordship. They had filed that later on, Lordship.
That is, it is part of the petition, my lord, that we have annexed.
So your observation
92.
your observation is unfounded.
My Lord?
Your observation is unfounded. You are referring to an order which has already been
Withdrawn.
petition which has already been withdrawn.
No, Lordship, this is what had transpired at that point of time. This is not with regard to the present bail application, my Lord.
You have to
They had not cooperated at that time with the
don't confuse the court.
Lordship.
You should stick to what is at present.
My Lord.
What is before the court at present. If
Lordship.
you refer to matter which have already been disposed of, then it becomes confusing.
My Lord,
Now,
this,
if I
this,
take cognizance of this, I'll say that they have not cooperated.
my Lord, this comes directly after the heading of first application for grant of anticipatory bail, Lordship. Then came the second round of anticipatory bail application, Lordship.
Again, this issue of non-available warrant of arrest also, it's in connection which case? This case?
The NBWA, Lordship.
Yeah. On 1st October 2024, the Honorable Court of Judicial Magistrate, First Class Revoi District, issued non-available warrant of arrest against the accused,
Lordship, this was issued, Lordship.
which remains unexecuted till date.
Lordship. Kindly, my Lord, just bear with me for just 1 minute, Lordship. The non-bailable warrant of arrest was issued on first day of October 2024, Lordship.
In this case,
Lordship, this is Khanapara PS case number 25-7 of 2024, Lordship. It's the same case, Lordship. Khanapara PS case number 25-7, 2024.
where's the related order of the court?
My Lord?
Where's the related order of the court in this case?
Related order, Lordship. Of the case withdrawn, my Lord?
No, of this non-available warrant of arrest.
the NBWA Lordship. This will be in the code of GMFC First Class Riboy District Lordship.
Where is the extract of that order?
My lord, I have it in soft copy, Lordship. I have it, my lord. Just. My lord, it's there in the extract of the CD, Lordship. Since there's no page number, I'll just hand over my copy.
Now do the last two line. Another aspect highlighted by the Learned Senior GA is the fact that in course of investigation in this case, the conduct of the petitioner is found wanting in as much as he has failed to cooperate with the investigation to the extent that a non-bailable warrant of arrest was issued against him by the Learned Judicial Magistrate First Class, Riboy District. On NBWA was dated was 1/10/2024, which purportedly has not yet been executed till date. It's because of the reasons aforementioned, the Learned Senior GA has reiterated that the prayer of the petitioner does not deserve consideration by this court, and this petition and the interim bail application may be discharged and the petition be dismissed as devoid of merits. As far as the facts and circumstances of this case is concerned, this court has produced the FIR, supra, and is of the view that the allegations made therein are serious in nature, more so as the conduct of the petitioner has been portrayed as one defying the due course of justice, by indulging in activities which are contrary to law. Though the allegations are yet to be proved in course of investigation and eventually trial, if so warranted, nevertheless, the complainant would not have made such allegation if there are no semblance of truth in the same. Secondly, since the inception of the FIR and investigation being launched, it appears that the investigation agency has taken steps to compel the petitioner to cooperate with the investigation, but that has also proved futile, even to the extent that his own place of residence at Jaipur, Rajasthan has been visited. The further contention of the prosecution that the matter has reached the stage where even non-bailable warrant of arrest was issued against the petitioner, the same not being able to be executed till date, would only cement the fact that the conduct of the petitioner is suspect as far as these proceedings are concerned. The fact that the petitioner has indeed visited the Khanapara police station on 16/2/2025 is only on account of the interim protection given by this court, wherein the details or the merits of the petition has not yet been gone into. Under such circumstances, in view of the gravity and nature of the alleged offence and more particularly the conduct of the petitioner right through the stage of investigation. This court is of the considered opinion that no further protection can be given to the petitioner. Accordingly, this petition is hereby dismissed as devoid of merit. The interim bail granted is hereby discharged. Petition disposed.
Much obliged, Lordship.
Same order will cover the next.
Item 15, Lordship.
Same order.
Same order, my Lord.
Petitioner different?
Lordship, this is just the in the first case it's the son, and the second in the second case is the father, Lordship.
Thank you.
Thank you, Father.
Change
Much
second
obliged.
cutting.
Obliged.
I know.
Dip.
Whatever original that you have produced for the court, you take it back.
Lordship, just the status report, Lordship. That is the original. But Lordship, it can, Lordship,
This matter has taken up actually the whole
the
session.
whole half, first half, Lordship. But we are deeply obliged, Lordship.
Deeply.
If I don't pass order in court, I sit myself, I have to sit again in second half.
Lordship. And because it's connected, it's best it's taken together, Lordship.
So as far as the other cases are concerned, we have to accommodate.
Lordship.
Thank you.
Much obliged, Lordship.
Item number 7.
New or 7, no?
My lord,
Yes.
we filed this for a regular bail, my lord. I've been in custody now for over 55 days. I'm not keeping in good health. I have severe medical conditions, and lately what has also come to term that I am also having some ailment in my liver as well as in my kidney. Having said that, lordship, there are other aspects also of the matter I'd like to argue upon, if I may, lordship.
What is the section involved?
My lord, all sections are warrant triable by a magistrate of the first class, my lord. I've been charged under 379, 403, 408, 409,
Maximum,
421 IPC and section.
maximum sentence?
My lord, 10 years.
10 years.
10 years. My lord, in this case, a 41A notice was also issued to me, and I was abiding by the said notice and I was cooperating. Despite that, after a period of 8 months, I was arrested. And the offence dates back to 2022. Admittedly, my lord,
Those PDS matter?
my lord, admittedly, the complainant also, in his FIR, he knows that the incident is of 2022. Still, he waits for 2 years and files it in 2024 May, the FIR. Now, the sole reason for filing the FIR as embodied in the FIR itself is that for the past many months, I have been trying to contact Shri Pankaj Gupta in his mobile phone, but he is not responding. So, he is filing the FIR. Now, my lord, another major contention that I hold here is that the grounds of arrest were never intimated and communicated to me, my lord. It is evident on the face of the record.
But under the
My lord, page 40.
under the guidelines laid down in the DK Basu case, you should have been informed.
My lord, not just DK Basu, my lord, there are 3 judgments recent from 2024 October, November till 2025 as we stand here. And in all the 3 cases, the Supreme Court has upheld the intimation of arrest is not supposed to be said in oral also. It has to be given in writing, not just to the person being arrested, but also to his relatives who are being intimated of the arrest. Now, my lord, page 44 of my application. If I may, my lord.
Yes.
My lord, this is the intimation of my arrest. there are no grounds which have been mentioned as to the reason for me being arrested. It says, my lord, the date, the place, and the case number, and the place where I'll be in custody, but the grounds of arrest, as need to be, my lord, have not been mentioned. My lord, relying on judgment, my lord, Pankaj Bansal versus Union of India. Para 32, internal page, my lord, 737. If I may. Para 32, my lord.
Yes.
If I may, my lord.
Yes.
That being so, there is no valid reason as to why a copy of such written grounds of arrest should not be furnished to the arrested person as a matter of course and without exception. There are two primary reasons as to why this would be advisable course of action to be followed as a matter of principle. Firstly, in the event such grounds of arrest are orally read out to the arrested person or read out by such person with nothing further, and this fact is disputed in a given case, it may boil down to the word of the arrested person against the word of the authorized officer as to whether or not there is due and proper compliance in this regard. In the case on hand, that is the situation insofar as Basant Bansal is concerned. Though the ED claims that witnesses were present and certified the grounds of arrest were read out to and explained to him in Hindi, that is neither here nor there, as he did not sign the document. Non-compliance in this regard would entail release of the arrested person straightaway as held in V. Senthili Balaji. Such a precarious situation is easily avoided and consequences thereof can be obviated by very simply by furnishing the written grounds of arrest as recorded by the authorized officer in terms of section so-and-so of the Act to the arrested person under due acknowledgement instead of leaving it to the debatable ipsit dixit. My lord.
We'll take up the matter tomorrow.
Tomorrow, Your Lordship.
Because time will not permit us. I have to, rise for lunch, for the break, sorry. Lunch or not, for the break.
My lord, I'm having a severe medical condition. I'll not stress on these grounds also. My lord had called for a medical report. I have to go for a liver check.
I have, Your Lordship. All those I have the medical reports.
Tomorrow?
Lordship, yes.
What, Mr. Nkira, counsel for the petitioner? The hearing is not concluded today and will continue tomorrow.
My lord, item number 1 and 2, my lord. The petitioner's counsel, Mr. Sheikh, he is out of his station. It was mentioned in the morning.
1 and 2?
1 and 2. Hassan.
Nobody has appeared.
I have appeared, Your Lordship.
You have appeared?
For the petition.
Yes.
Your Lordship.
So what do we do?
Because he is out of station.
Who's out of station?
Mr. Hassan.
Oh. But you are there. She is there. She has been.
Number 9. What to do? We'll do after 2 weeks. We'll have it tomorrow, my lord. Because
I'll be there tomorrow.
then take your time.
No, sir, I'm ready.
Then we'll take it.
Tomorrow. Let's have your name. Huh? Atli? Fine, tomorrow.
Reply, please.
On payment by the parties, this is matter tomorrow.
May it please Your Lordship. Lordship, item 9, if this matter can be taken up on some other day, Your Lordship. Item 9, Your Lordship.
You are, who's for the petition?
Lordship,
I'm for the petitioner, my lord.
after 2 weeks, Your Lordship, we have agreed.
On payment by the. On consent by the parties, this is matter after 2 weeks.
Oblige, Your Lordship.
My lord, item number 14 and 16 may be kindly taken up tomorrow, my lord. This is also bail application. 14 and 16.
You see, I have to, adjust that the time. Because in the morning, if I take too many matters, and I have to sit again,
Yes, Your Lord,
it becomes very, I feel sorry for having to adjourn matters like this.
Yes, Your Lord, we are also.
Let's just see, Day after tomorrow.
All right. Obliged.
Lordship, I beg to mention
14, 15,
14 and 16.
14, 16.
14 and 16.
Yes.
What about this 15? 15 is
15
not-
disposed of.
Huh?
13 and 15 already disposed of.
Oh, 13. Okay.
13, 15.
Sorry.
Lordship, I beg to mention item number 8, Lordship. Lordship, I'm praying if the matter can come up somewhere on 12 or 13, my lord, for my Advocate General to address, my lord. The hearing has already been concluded. My lord wanted to re-hear the matter again. So I'm praying if the matter will come up on 12 or 13, my lord, of March.
Yes, Mr.
Hello,
I'm pre-made by Mr. S. N. Gupta. When I
G.
list this matter on
13th.
13.
Obliged, my lord.
Not objected to by petitioner.
May it please, Your Lordship. Lordship, item numbers 11 and 12. I'm the appellant in both matters. If matter can be taken next week, my lord, after a week.
These are relatively new matters, so
Fairly.
2 weeks
2 weeks.
on pre-made by Mr. S. Tindal and comfortably appellant. This is matter up to 2 weeks.
Both 11 and 12, my lord.
Fine.
Obliged.
Now we are left with 10.
Lordship, this item number 10 is that teacher matter, Lordship. Lordship, they are supposed to file their affidavit. Lordship, but those affidavits are not been filed yet, Lordship.
After 1 week.
Short date may be given, Lordship.
1 week.
1 week.
Yes, miss, you are in this case.
Obliged.
You are supposed to file the affidavit.
No, Your Lordship.
No, this is for it's the state, Lordship, who's supposed to file. This is that teacher matter, if Lordship
What
recollects,
is there?
that for regularization of my service. Lordship has already directed in the last order, also in order dated 24/6/2024. They were supposed to produce the documents to prove that my service was not continuous in nature, but they failed to produce since last year in the month of June till today, Lordship. And then next, Lordship, they're taking that other plea that I've set for that exam, that selection process. That also, Lordship, they said they'll produce that advertisement and all, Lordship, but then nothing has come forth, Lordship, till now. So they failed to prove that my service was not continuous in nature.
They have to file the
Lordship, they are not there, Lordship, but
on pre-made by parties. This is matter up to
1 week, Lordship. Short date maybe.
1 week. 1 week.
Lordship. Deeply obliged, Lordship.
Yeah.